Good afternoon. This is Raymond with SmoothOperationofLaw. And what I'm going to do today is I'm going to talk about registered trademarks. This is not legal advice. This is more reporting. Okay, guys? I don't want anybody taking this as legal advice. It's just reporting. Now, tmep.uspto.gov is where you're going to find your trademark manual for examining procedure. That means that this is a government website. This is tmep.uspto, which is the United States Patent and Trademark Office, .gov, right? So governmental. So it's the trademark manual of examining procedure. What I want everybody to see is that if you are going to actually register your trademark, the manual states, and let me scroll, that you can do it as a trustee or a conservator or an estate. It even gives you the language. These are examples. These are examples of the language. Now, if you're going to run a business trust, it's right under it. And they give you the examples of the language. Okay? If you are establishing an irrevocable trust because you do not want to have the trademark in your hand, that way any type of trademark infringement or any type of debt collection will not be placed against you per se when it comes to your trademark, i.e., let me explain that better, i.e., you don't want to control the trademark directly because, let's say you signed a loan. If you signed it and that is your trademark, then you have given permission for the trade. So by putting it in an irrevocable trust, you place it in a separate legal distinct entity that never signed shit. If I had a loan against me, that's one thing, and I can get permission. But if the trust has a problem with someone using its mark of trade and that trademark happens to be eerily similar to your name, the trust still holds as a separate legal distinct entity a right of claim through the courts against the loan, therefore allowing the trust to get an injunction against your loan even though they are not signatory, because they are not signatory. If you're getting what I'm saying right there, then in short, you can pretty much flank a personal debt obligation with a claim coming from a separate legal distinct entity that would allow for an injunction, which is a court order for someone to refrain from doing or compel them to do, like pay you, which would be given on behalf of your trust. The trust is not you, but ultimately, you will no longer have to pay that debt, inherently that is, because there would be an injunction placed against the transaction from ever existing. I've talked about common law trademarks. You can check that video on the YouTube channel. It's in the history. And I've already explained that you do not need to file a trademark. You will still get, if you are conducting interstate commerce, protections under the federal statutes of 15 U.S.C. 1122, which will waive the immunity of a sovereign, which is also solidified by the case precedent, which was adjudicated June 6th, 2020, in the case of Allen v. Cooper, which creates a situation for states where if the trust sends them a cease and desist and gives them notice and the state willfully violates the law because they were given a cease and desist to stop, then what happens is they meet one of the prongs of what was adjudicated as a requisite for waiving the sovereign immunity of a state entity who violates intellectual property rights. And that is willful infringement. Or 2, where there is no adequate state remedy. And if it's a state and they are not giving remedy when it is against the law, and there is a waiver of sovereign immunity, and they've been put on notice, then there is no adequate state remedy. Sending a cease and desist gives you both prongs. Both prongs that are the requirements for Allen v. Cooper to hold. You've been notified. So, why am I talking about registered trademarks? Am I sending you to register a trademark? No. Not telling you to do anything. But you can register your trademark and get further action. Is it better action? Well, it depends. Depends on your patience level, depends on what you're really trying to do. The way that I do it, irrespective of registered or not, it doesn't matter. And that's because the way that I do it isn't just strictly through litigation. That is not how I do business. Why would I want to do business through litigation when things can get political? So, you can consider this an explanation for why you should register it or why not to register it in a reporting format. Because I'm only showing you that, 1, it can be registered, your trademark that is, that it does exist in the manual, and that if you are going to have a trust where you're going to have your trademark, you better register it as a trustee, not as an individual. But if you are not going to register it, then the way that I do it, it's even faster than litigation. Because I like to go to arbitration. And I'm not going to get into that in this class, and I have never made a video on that because I'm not giving that one up at all. But if you're still tracking and following what I'm saying, the difference between registration and non-registration is that when you actually register it, you get certain levels of protection coming from customs, coming from, the different agencies of the alphabet agencies that help with trademark infringement. I'm not going to go through all that right now. But the agencies will be with you, as opposed to you just having to get some sort of preliminary injunctive relief and wait for just a specific court to review the validity of your trademark and then issue you some sort of emergency temporary restraining order or injunctive relief. If you do not understand any of the words that I'm saying, then you might want to look up what temporary restraining orders are and what preliminary injunctive relief is and what injunctive relief is, or what is an injunction. Oftentimes, when I make these videos, I have comments or issues with people understanding some of the terminology because they don't do their homework. But if it's in a video format, go ahead and interrogate the video and reverse engineer the terminology by using Google. Don't be lazy, just go Google it. And then don't act like, I don't know what the hell you're talking about. No. I said it, and I'm even highlighting it. So, what are the benefits of a registered trademark? I've already told you. What are the benefits of an unregistered trademark? Well, here's the deal. If the USPTO wants to sit there and kick your trademark off because they think you're a nuisance, then understanding operation of law means that you don't need their approval as long as you have good court skills. And by good court skills, that means that you better come in with a lot of case precedents, like I just gave you, Allen v. Cooper. Those court precedents are controls to the lower courts. If the Supreme Court says something, then who the fuck is the lower court to sit there and say, well, in my lower court capacity, I am now going to exercise some sort of discretionary appellate power when the criteria of the situation and the facts at hand are exactly consistent with that Supreme Court precedence. To do so would be ultra-vires or out of office or out of pocket. It would maybe be awarded in the lower courts, such as a district court. They would say, hey, you know what, we're not listening to that. But it would most definitely get appealed at the circuit. And no judge likes to have an ill rub or smudge on their history of failing to follow Supreme Court precedents. And considering the fact that Allen v. Cooper is so recent as June 6th of 2020, that judge would literally be saying, fuck you and the 9 justices of America. He would Allah Akbar his goddamn judicial record. He would look like he's the only clown in a black and white photo with a red nose. Be advised, I'm just reporting to you. Any questions, comments, concerns, or interests, go ahead, look in the description of this video and hit me up on Messenger or something. Have a good day.